I just would like to clarify at the outset that I did not handle the Catano case when it was before the Supreme Judicial Court. The case was handled by the district attorney rather than the Attorney General's office at that stage. In the Supreme Court, the argument that I made—
Wait a minute, you didn't, the Catano case at the U.S. Supreme Court, you didn't handle it?
I did co-author the brief in opposition to certiorari at the Supreme Court,
Okay.
but not the Supreme Judicial Court.
I'm asking you about the Supreme Court, the Supreme Court judgment that rejected your arguments. So you've just confirmed, I think, that you made those arguments to the United States Supreme Court. Is that correct?
Respectfully, Senator, the argument in that brief was slightly different. The argument was that a stun gun is, we argued on behalf of the Commonwealth, not an analog to a founding era weapon.
Which the Supreme Court rejected unanimously.
The Supreme Court held that the Supreme Judicial Court had misstated the Heller decision in 3 respects. But again, I didn't handle the case in front of the Supreme Judicial Court.
So your argument is that your position wasn't rejected unanimously by the U.S. Supreme Court?
I certainly acknowledge, Senator, that the Supreme Court summarily reversed the Supreme Judicial Court's decision. And I would adhere to the Supreme Court's holding in Catano and reaffirmance of Heller's statements.
Here's what I'm trying to understand. The Supreme Court was very dismissive of your arguments. One of the reasons it was dismissive is it said they've considered these arguments before and rejected them. This is why they then rejected your arguments per curiam, unanimously. So I'm trying to understand why someone who has ethical obligations to the court, why you would make arguments that the court has previously rejected, knowing that they'd previously rejected them. And then here's the other thing that interests me. In this case, the person who had been arrested under this law that the Supreme Court then reversed on was the victim of domestic abuse. And I just want to read a few of the facts here. This is from Justice Thomas and Justice Alito's concurrence in that per curiam judgment. Here's what they say. After a bad altercation, that's from the trial record, with an abusive boyfriend that put her in the hospital, Jamie Catano found herself homeless and in fear of her life. So she obtained multiple restraining orders against her abuser, but they proved futile. So when a friend offered her a stun gun for self-defense against her former boyfriend, she accepted the weapon. And it's a good thing she did. Because one night, after leaving work, Catano found her ex-boyfriend waiting for her outside. He started screaming that she was, this is from the trial record, not gonna effing work at this place anymore because she should be home with the kids they had had together. Catano's abuser towered over her by nearly a foot and outweighed her by close to 100 pounds. She stood her ground, displayed the stun gun, and announced, "I'm not gonna take this anymore. I don't want to have to use this stun gun on you, but if you don't leave me alone, I'm gonna have to." And the gambit worked. The ex-boyfriend got scared and he left her alone. You think she shouldn't have had the right to self-defense?
Senator, thank you. Again, the district attorney made the decision to bring charges in the Catano case. The Attorney General's office and myself were not involved in that decision, but I certainly recognize
that you argued for it to be upheld before the United States Supreme Court.
Senator, the argument in that brief was that the Supreme Court should deny review of the case.
Right,
But
which deny the right of self-defense to this person. I'm asking you why.
Senator, my duty as Assistant Attorney General was to represent the Commonwealth in that case when it came to the Supreme Court, and I did so consistent with my ethical obligations.
Your duty is not to make frivolous arguments to the Supreme Court of the United States. And frankly, I question your judgment in what you did in this case, and I question your judgment in choosing to try and perpetuate what is meant